Hello and welcome to the latest edition of the Psych Tech at Work podcast. I am your host, Dr. Charles Handler, and boy howdy do we have a special guest for you all today. You are going to love this. Our guest, my guest, your guest, is none other than the Commissioner of the Equal Employment Opportunity Commission. That is right, Commissioner Keith Sonderling. And during our discussion today, we're going to cover all kinds of hot topics, all kinds of things that relate to the ins and outs of how people are going to hire today and in the future, right? In the age of AI, are things more complicated? Absolutely. Are the core ideas of what it takes to hire ethically and responsibly any different? I don't know. You be the judge. In my opinion, and maybe in Commissioner Sonderling's opinion too, it all boils down to some really simple principles, which we'll talk about today. At the same time, you're going to hear straight from the horse's mouth what we can expect from the federal government in terms of new laws, rules, regulations, policies, all that good stuff. We'll also talk about the impact of things like the EUAI Act at the global level, and even things like the New York City law at the local level. That's right. What we're going through now is a groundswell of thought, consideration, and careful deliberation about what it's going to take to make sure that hiring is ethical, responsible, and happy for everybody involved, right? It's a tall order. So without further ado, let me introduce my all-star guest for today, Commissioner Keith Sonderling.
Good. Thank you for having me. I'm really looking forward to our conversation.
This conversation, I think, will be very enlightening. I have so many questions to ask you. I'm not even going to be able to get through all of them because I've been deeply entrenched in, legal compliance for testing for 20 some years. Having worked under a consent decree before in public sector and having done litigation support and advising my clients. And it's not as easy. It's never been easy. I don't think it's as easy now as it used to be, or at least kind of what we're thinking about.
No, and I mean, think about now how this is being driven by technology. I mean, before the work, in your field you were doing was largely driven by getting people to go to places and take tests on pencil and paper and Scantrons. And, the democratization that technology is bringing to your field is like something we've never seen before. So an area that normally was reserved to knowledge workers in corporate settings, once you reach a certain level, as an executive now can literally be used for your entire workforce. So thank you for being in this industry. Thank you for being a pioneer for a long time, but I think it's really going to really reach new heights that we haven't seen before.
Yeah, I agree. And so before we get into it, tell the audience here, and I'm curious as well. I mean, of course, I looked at your background, but what's your career journey been, and how did you end up sitting in that seat with the wonderful flags and official stuff behind you there?
Well, I was a labor and employment attorney in Florida before joining the government. So I was defending corporations and HR departments when the EEOC or Department of Labor would bring actions, or private lawyers. So I first learned this industry from kind of coming in after the fact when things had gone wrong and sort of seeing and having to defend those actions. So that was a really great experience for me to learn how HR operates, to learn how employment decisions are being made lawfully, sometimes unfortunately unlawfully.
Yeah.
And then in 2017, I completely left the beautiful state of Florida, where there's a lot of sun and palm trees, to move to Washington, D.C., where I joined the U.S. Department of Labor's Wage and Hour Division. The Wage and Hour Division deals with some pretty significant employment laws, such as obviously the Fair Labor Standards Act and how employees are paid, in addition to the Family Medical Leave Act, a lot of the payments related to agriculture workers, government contract workers, and under the Immigration Nationality Act, those wage provisions there. And then in 2019, I was nominated to be commissioner on the EEOC. I had to go through the Senate confirmation process and then was confirmed in 2020. So this is sort of the world I've been in labor and employment, but obviously here at the EEOC, especially for a labor and employment lawyer, it's really a dream come true, because I always say that this is the pinnacle agency worldwide when it comes to civil rights in the workplace. The EEOC, is the governing body for human resources. It is the agency that protects all workers from entering and thriving in the workforce without being discriminated against, and making sure equal employment opportunity is promoted. So this is an opportunity of a lifetime to be here. Really have enjoyed it. And one of the more important parts of my jobs that you alluded to in the introduction is getting out there and speaking to as many practitioners as I can in this role.
Yeah, that's a huge thing. I see you popping up all over the place, talking to a lot of friends of mine or people who I really respect, and their opinions. And I think that's just so important, instead of just saying locked up there. I'm sure you have plenty of work to do, right? But being able to get out and talk about these issues, I feel like you're going to be learning a lot and educating. So tell us a little bit about this. What are some of the most interesting and impactful conversations that you've had, and how do you think those might have influenced all of us who are working so hard to make this stuff work properly?
Well, when I got to the EEOC, I wanted to be forward thinking, and I wanted to, talk to people in the HR community, see what the big issues are. And at the EEOC, it's just so easy to allow the news or what's going on to kind of swing the direction where we need to use both enforcement and compliance resources. So if you think historically, let's look back at the last 10 years. The EEOC started to focus on issues like age discrimination. And then the Me Too movement happened. And we had to stop and shift all of our resources related to the Me Too movement cases, compliance related to that. And then COVID happened. And then it was all about, early on about accommodations in the workplace. Can you work from home? Can you test your employees for COVID? Then the vaccine came out. Can you exempt can employees get exemptions related to COVID for religious reasons? And then George Floyd, and then racial discrimination and diversity, equity, inclusion became front of mind. So it's really, in this job, you can sort of go with the wind, which is important. And we still do, as like what I call the day job in that sense. But I really want to say, well, okay, knowing all that is always going to happen, how do we get ahead of the next large issue? And that's when I found out the biggest issue on chief human resources officers' minds and HR departments' minds was the whole issue of technology in HR and artificial intelligence in the workplace, and how that was going to impact not only the HR practice itself, but also employees and applicants being subject to these tools. The amount of technology out there to make HR decisions faster, more efficient, but also more fair, and to remove bias can really get your head spinning with the amount of offerings and the amount of programs. And look, all of them promise one thing: to make better hiring decisions, to make hiring decisions without bias. And as you quickly learn when you start looking into HR technology, there's a lot that goes into that to actually get there.
Yeah.
So that's sort of been my mission, is how do we get there? How do we use these tools to actually help employers take a skills-based approach, which is, a very big buzzword in HR, where a lot of people want to get to, and actually have hiring be perceived and actually be fair and prevent discrimination from occurring. And, AI tools really have the ability to do that. But at the same time, they have the ability to discriminate more than any one individual human being. So a lot of it is now, okay, how do we discuss that? And how do we build that into the ecosystem of HR technology? And I found out there's a lot of players involved.
Oh my gosh, it's a giant. In fact, I was talking to somebody the other day who was an analyst and was saying the HR tech industry itself has so much more going on than a lot of other industries when it comes to technology. There's so many pieces. They're often very disparate, like the hiring system's not really talking to the internal mobility systems or the compensation systems. There's a lot of that going on. And, technology is impacting everything. Hiring has been, I've been kind of on both sides of the hiring when it was pieces of paper to the first job boards to where we are now. And it's pretty incredible. And I agree. I think it was a really interesting point you just made, is that these systems scale, right? A big piece of this is scale. So if you train a system that has bias, it's going to scale that bias, over and over and bigger and amplify it. So we kind of got to cut it off at the root,
And there's a lot of different ways to look at that. And you brought up a really good point. And so much of, I don't want to say the analysis or the distraction in these AI tools is, looking at this data set discrimination. And what does data set discrimination mean in terms that you don't need to be a computer scientist to understand? What is that for
Yeah.
HR professionals? And, kind of simplifying that, well, what is the data? It's your applicant flow. It's your, where you put your job boards.
Yeah.
And then, who applied for the job, or, a lot of these tools analyze your existing workforce, your current
Yeah.
workforce. And, the simplistic examples of that are, okay, so if your applicant pool is made up of one race, one gender, one national origin, the computers may think that that is the most telling sign of what an ideal candidate is. And obviously it's a lot more sophisticated than that. But you brought up just now a really interesting point that it's a lot more than that, right? And how that individual bias can be injected into not only that data set, but also how it's analyzed and how it's run. And I think that's sort of the fear of all this, and not just having your data set properly and making sure that you've done what you're required to do, whether you're a federal contractor or just in EEO, policies regarding hiring and advertising, but also, access to these systems. And if you have somebody who has access to the systems in HR, hiring manager or otherwise, that now has more access to data than ever before and can inject their own bias into systems, and the systems be able to recognize that, I mean, you can eliminate individuals who are qualified from the applicant pool based upon their race, sex, national origin, religion, etc.,
Yeah.
with a few clicks. And as
Yeah, you can.
when things were on paper, it took a long time to discriminate. So you have a hiring manager who wants to look at physical resumes, and you want to look for, you don't want to hire any women for the job. You have to look for female sounding names. You have to look for characteristics associated with being a female with your eyes and saying, okay, male or female, female, trash. Oh, this is a close call. Let me look longer. It takes a lot of time, right? But
Yeah.
these systems are so sophisticated, whether directly or adjacent characteristics, to be able to pick up that. And with a few clicks, it could be catastrophic to an organization of injecting bias in there. So that goes to the broader conversation about how it's just so much needs to go into properly designing these tools from the vendors, carefully using it from the employer's perspective. And that's what people are trying to figure out now. And I think that's where a lot of people have different roles in, whether it's lawyers, whether it's IO psychologists. We need to create that sort of universe of who's involved in actually making sure that these tools are not only doing what they're saying they're going to do, but also legally compliant and also, ethically compliant within the confines of your organization. And that is what I'm trying to figure out. And it is very
Yeah.
complicated.
It's the Gordian knot, if you will, but hopefully we can conquer it. So something that you were saying there, and a thought that I've had, and I've expressed it a lot, but I can't keep saying it enough, and I'm very interested in your take too. I feel like hiring is a game of probability. You can't hire a plaid person if they're not in your funnel, right? It just doesn't happen. So if there's misrepresentation going into the funnel, it's going to be harder to have something equal, come out the bottom. And I feel like maybe the great Satan, I would say, in a lot of the stuff we deal with, is who even sees a job ad. The algorithmic placement of a job ad. If I'm, an African American female IT professional or developer, and whatever algorithm doesn't even show me a job opening potentially, I can't apply for that job. I've already been discriminated against. And then you have these recommendation engines, right? Even before someone is a candidate, a recruiter or a sourcer may say, oh yeah, thumbs up on this person, thumbs down on this person. That trains the system as to what you want. And if there's bias there, even before someone's a candidate, you're ejecting people that don't fit. And you're reaping the issues with that when you're trying to be compliant with everything else. Can we stop that?
And you're liable for it. And that's the thing, as you know, as some people don't know, federally, job applications are federally protected. I mean, job descriptions, advertisements are all federally protected. Before we get to the content of what's in those, where there's generally a lot of issues, but to your point on the advertising side, and I think this is where we saw some of the issues very on, and especially the way big tech companies are designed, especially the way they make a lot of money is through advertisement and through placements and having what's called, these micro-targeted ads, and to show you based upon your demographics, based upon all your protected characteristics of, hey, we want to show you this product. because you're likely to buy it. And look, in the advertising, selling shoes or selling electronics, that's completely illegal. I mean, that's completely legal,
Yeah.
and that's how they make a lot of money. But in the employment context, it's completely different in that sense. So,
Yeah.
if you're going to say that I want to only show this job advertisement to this group of people based upon all this demographic information I have from these tech companies now, right? You are, like I say, going even further than pre-civil rights era discrimination, because at least before technology, if you saw job advertisements, and there's some crazy examples from the
Yeah.
pre-1960s civil rights job saying, no
Yeah.
women of childbearing years apply.
Yeah.
No
No
Irish need
Irish
to
need
apply. Right?
apply.
Yeah.
Yeah, that's a big one
That's the
from the
famous one in New York
1800s.
City.
Yeah.
Yeah, if you
Yeah, yeah.
Google it in black and white, no Irish need to apply. At least
Yeah.
then you knew you were being discriminated against because of protected characteristics. So if civil rights
Yeah.
laws existed, you would at least say, hey, here is where I'm being discriminated in the job advertisements. In the scenario you gave, when you're using those same tools unrestricted to have a job advertisement, and there's an example of this, a case brought by the ACLU, not by the EEOC, regarding Facebook, saying that a lot of employers could use the same advertising tool that they could otherwise for products. And it was a state-based age discrimination case. And they said that they went in there and they limited the job advertisements. Let's say they're just the 20 to 25 years old, as an example,
Yeah.
saying, we want recent college graduates or people in that age frame. So everyone, outside of that group who didn't see the job advertising because they were limited, if they were qualified for the job, they could potentially have a claim against that employer for age discrimination, if they're over 40, or
Yeah.
just, that one example at scale, right?
Mm-hmm.
Having the existence being withheld based upon your protected characteristics. So you could see quickly just on the job advertising fine, just trying to find the right candidate, having those kind of closed advertisements versus broadly putting it out there and letting the most qualified people apply, regardless of age, regardless of
Yeah.
sex, etc.
Yeah. Yeah. And you mentioned selecting people in an age group, but I believe a lot of those tools are completely algorithmic, and you don't even have as much choice as an employer maybe as where stuff shows up. But we've talked about problems, and we could talk about the problems till the cows come home here, but let's talk about the solutions to the problems, and specifically legislation, because we're entering into, I would say, a new era of legislation, and AI is requiring that. And legislation does not come quickly. There's a lot that has to happen. The bill on Capitol Hill from the Schoolhouse Rock, if you've ever seen that, maybe I'm a lot older than you than you at that, but there's are cartoons that help teach kids about government and science and stuff back from the 70s. So there was one called The Bill, and it works its way through Capitol Hill. It's very entertaining and important. But let's start with the biggest. We're going to talk about a couple of different significant legislations based on geography, really. So let's start with the biggest, broadest one, and the EU AI Act, which was just passed, right? And my thoughts, I originally was thinking, well, it'll be just like GDPR. It'll be an adopted standard because it makes sense and it's well defined. But GDPR is simple in some sense. These are the requirements for your data. These are the things you have to do. There's not a lot of gray area. With the EU AI Act and any AI Act, the gray area becomes gigantic. We are immersed in gray, a sea of gray sometimes, and we got to hack our way out of it. So what do you think about that act? How's that going to influence things here stateside?
Well, I want to take a step back because it's really important to remind everybody that there are laws in place that deal with algorithmic decision making just as they deal with human decision making in the United States. And, from our perspective at the EEOC, whether a employment decision is made by a human or an algorithm, liability is going to be the same. It's going to be for those companies. So if we're seeing what AI tools are doing, they're either making the employment decision, hiring, promotion, benefits, training, etc., or they're assisting in that, right? And that's where you hear a lot of the human in the loop. But either way, there's going to be an employment action, and that's what we regulate at the EEOC since the 1960s. So before we get into the sometimes chaotic discussions of what foreign and state governments are doing, we can't lose sight of the fact that the EEOC is going to ensure that every employment decision that is made does not have bias, including with algorithmic tools. So
Yes.
I like to remind everyone of that because there's a lot of confusion of whether or not we need new laws, whether or not we need new agencies, and that if that happens, it will happen. But in the meantime, you have to still comply with federal law.
Oh, yeah.
So
And I have definitely reserved some time to talk about the uniform guidelines. I
right.
don't know if now's and there's other legislation too.
Yeah, no,
Um,
let's pick up with I just have to have a disclaimer
yeah,
because because the technology is so new, because people don't understand algorithms and the technology.
right.
You know, either the fear of using it, which is not good,
No, no,
or
no.
or we can use it unchecked because the U.S. hasn't passed a global AI bill, right? They're both misconceptions. So
Yeah,
let's start with the Europe because it's very hot right now. It just was passed, and it is really the first global standard, just like
yeah,
GDPR.
it
And what
is.
happens when you have global standards? That starts to infiltrate other countries as well that do business there, and for multinational employers that are going to be subject to one law. It's just from a compliance perspective, sometimes it's easier just in a sense to federalize that law, right?
Yeah,
Even though
yeah,
there's no federal standard. So the EU, the EUAI Act has taken a much different approach than really anything we have in the United States, where they're saying we're going to assess AI based upon risk-based categories from
yep,
low risk to unacceptable risk and everything in between. There is some confusion over this, but for conversational purposes, for the most part, using AI in HR is going to be considered a higher risk category,
absolutely. It
and
is.
because you're dealing with people's jobs, you're dealing with their livelihood. So there's good reason they put that in. But then when you dig into it, there's different levels of some of it, like having a chatbot schedule an interview is obviously not going to be the higher risk. So
Yeah,
let's just lump it all in that category. And
yeah.
what it comes with is a few things. A lot more disclosure, a lot more
Hmm.
testing, a lot more auditing, a
Yep,
lot more, a lot additional consent requirements, and then just really significant penalties,
yep,
including, this is more of for law enforcement, but it also touches into employment, banning AI that can deal with some of the emotional affect,
yeah.
emotional
Facial recognition
facial
is
recognition,
banned.
things like that. And also, much different than the state of affairs in the United States, which we can also get into, is that they are saying that vendors are going to be liable for these tools. So,
Yes.
taking it a step back in the United States, only an employer can make an employment decision, and we
Yep.
essentially define that our jurisdiction is over employers, companies, unions, and staffing agencies, right? So
Yeah.
that's our world, and in the United States, those are the only groups that can make an employment decision. Though they're only one subject to our decision. You didn't hear AI HR tech vendors anywhere in that list
Yeah.
from the 1960s when our laws
No.
was established. So the EU is saying that they're going to be liable as well, which certainly puts more skin in the game for the vendors, which they don't necessarily have here in the United States. So what does this mean? It means that to use these tools there's going to be an extra level of governance, an extra level of testing, similar to what we're seeing in proposals here in the United States. Let's just take a step back and look how the United States has addressed AI in HR. And it actually goes back to 2020, where the state of Illinois was really the first one
Yep.
to dive into this with their
They
Facial
were.
Recognition Video Act, which essentially bans facial recognition in interviews. You could do it, but there's so many consent requirements, there's so much
Right.
to it that it's almost impossible to use. And then New York City's local law 144 was really the first all encompassing, and obviously, one of the biggest and greatest cities in the world, putting out a law specific to AI, calling it
Yep.
automated employment decision tools. But you look at it, there's been a lot written and a lot debated,
It's
discussed about this.
weak. I think it's weak.
That's your own commentary.
Yes,
As
I
a
know.
government official,
Yeah, I
I
know.
can point out that it only applies to hiring and promotion. And the way it defines what an AI tool is, as there's been a lot of articles on, has allowed a lot of employers to say, well, our use of this AI tool doesn't actually meet the definition of New York. So then if we don't meet the definition of using an AI tool, whether it's making a selection or ranking or whatever the ways out of it are, then we're not going to have to do this. But let's take a step back and let's look at some of the similarities between that and the EU. So
Yeah.
in New York City, they're going to require consent. They're going to
Yep.
require disclosure. They're going to require a pre-deployment audit. They're going to require a yearly audit. They're going to require you to post those results on your website so that the public can see it
Hmm.
as well. So those are common themes between, EU
Yeah,
and
yeah,
some
of
of our
course.
current proposals. But if you look further at it, saying, okay, well, it's only going to apply to hiring and promotions, and it's only going to apply to the EEO1 categories of race, sex, and ethnicity.
Not
So
even
in a
age.
sense, you can not even age, not even disability, not even
Yep.
religion. These other laws that the EEOC is going to say, well, you still need to be compliant to make sure that your hiring assessment programs are not discriminating against, certain religions, certain disabilities, certain,
Yep.
ages, or not based on genetic information. You can kind of go
Yeah.
down our laundry list where you can have a false sense of security almost being lulled in saying, well, look, I did a pre-deployment audit. I did a yearly audit for New York. I'm good, right? Like my tools are completely validated and fine. And then the EEOC comes
Mm.
in because, of course, federal law still applies in New York and saying, okay, well, how about when it was used for compensation? How about when it was used for terminations? And
Right.
how about the impact it had, on this group you didn't even test for? So, you could see a lot of it. It's adding on additional requirements, but, not everything. So just being in compliance with one place is not
Yeah,
necessarily ensuring compliance.
I know.
However, I do want to say though, what are the benefits of that though? So if you're doing an audit, if you're forced to do an audit, then if you're eliminating bias, even if it's on those categories, right, that New York has deemed the most important, then if you see a disparate impact, if you see discrimination, you could adjust the tool before it actually ever discriminates and then be in compliance, with our laws, which we've encouraged employers to do assessment audits. So, it's not all, you can't look at it all as negative. There can be some
No.
positive to it. So that was a long-winded way of talking about some of the, proposals and how it already meshes up with existing law.
Uh-huh.
But you're starting to see some of the common threads. Like there's only
Yeah.
almost so much they can make up to require employers before using this.
So I've got a couple of,
Yeah.
I don't know if they're counterpoints about New York. You can see I'm chopping up a bit. Is it a good thing? It's great to have these things started. What I don't like about the New York law is there is no actual mandate of remedy. You have bias, you've got to post that you have bias, but as far as I know, and I've studied it pretty closely, you don't actually have to change anything. Now it would under the federal umbrella there or roof, you definitely would be identified as somebody who's got a problem, and then you would need to rectify it. Also, there's no requirement of validity. There's nothing that says that what you're using to hire somebody has to actually be related to the job. It just doesn't have to have bias. So I don't like that part of it very much either. The final point is it doesn't hold the vendors accountable. The vendors should be able to provide their historical data or support that. But just like with the present state now and different from the EU is, vendors are selling guns, but they're not necessarily on the hook if somebody shoots another person with the gun. They typically are going to support you and want to help, of course, but it's not mandated. So those are a couple of the things on the New York side that, and I don't want to. I've had a guest on here and people that I know where they're like, it's actually just big business influencing that New York law so that it doesn't have enough teeth to get people in trouble. And maybe even we can supplant things like the uniform guidelines with a little bit of a grassy knoll conspiracy theory that may not be true, but you could see the controversy just with that law that's happening.
Yeah, and you raised some good points there as well. And not to get too technical, but if you look at the pre-deployment audit side for New York, if you don't have enough of your own data, you could use generic data or mixed customer data.
Right.
And in your career, as you know, that's unheard of, right? That
Yeah.
means absolutely nothing to us at the EEOC. Because if
Yeah.
we do a bias audit, we're only looking at how that tool was used on that specific job
Exactly.
advertisement, that
Yep.
applicant pool, and nothing else.
Yep.
And that is just going to be a complete false sense of security that, hey, these tools are in compliance. Well, as you know, you could cherry pick data from any kind of publicly available employment data and, have no discrimination, but it's so specific to that one individual employer's uses of it. Well, but then I do want to kind of counter also about, okay, so New York's requiring a bias audit. EU's requiring a bias audit. Well,
Yep.
let's get to the point of, well, how do you do a bias audit, right?
Yeah.
And
Good question.
if these state and local and foreign governments, want to take up this very complex topic of algorithmic discrimination and bias audits, okay, well, what's your solution? What is
Yeah.
your, if you're creating these new laws, these new requirements on employers and, not doing it through the federal process, okay, what's the standard you're going to use? There's been a standard at the EEOC since 1978 where you have generations of IO psychologists trained on. In the meantime, nobody's come up with anything different. Nobody's come up with a new standard that has been universally accepted, and the global universally accepted standard is not always used, right? So
Yeah.
in that, what happens? How do you do an audit? Well, look to the EEOC. Look,
Well,
look,
but
to, look to Title VII employment disparate impact testing, right? So that's sort of like, okay, so you ginned all this up, and then it's falling back in our lap here in a good way for the IO community at least knows how to do it, but they didn't come up with a new standard.
no, it's a 4/5 rule of ratio analysis and nothing else. And you don't audit the algorithm, you're just auditing the output. So, what it could be chickens, playing tic-tac-toe behind the scenes. In the New York thing, at least, nobody is actually accountable for that. They're just accountable for that ratio at the end of the tunnel. And even in sometimes, and I've done a lot of adverse impact analyses over the years, sometimes you got empty cells, a lot of empty cells where you can't actually have the substance to show the ratio, and that can be problematic too.
And
So,
the other part too, and what people in this world who are look, a lot of the vendors, a lot of the HR buyers are now suddenly walking into employment assessment testing world because that's what essentially these tools are doing, just
yeah,
modernizing it, and then
yep,
have never dealt with how do you test for disparate impact. And
yeah,
as everyone points to the EEOC's 1978 guidelines on uniform employment selection procedure, the 4/5 rule, and as the global standard, this is the get out of jail free card, right? That terminology that a lot of people like to use. But as you know, in 1979, the EEOC put out frequently asked questions related to the
yep,
1978 guidance, which is still on our website in 2024, that says the
yeah.
4/5 rule is one of many ways to test
One
for
of
disparate
many.
impact.
Two
And the
SD
EEOC
tests.
will
Yeah,
use it sometimes, and they'll
yep,
use another standard. So
yep,
the reality of it, there is no universally accepted standard. And what happens is when these cases actually get to law enforcement, when they go to court, they hire experts and it becomes a
yep.
battle of statistical analysis. And that part of the equation, which IO psychologists have been dealing with for a long time and data scientists understand, hasn't surfaced yet this is a lot more complex than doing a generic audit under the 4/5 rule.
Absolutely. And I'm glad you're talking about the uniform guidelines. Obviously, they're pretty important. And my experience is definitely, when we do this, we look at a 2SD test, which is sample dependent, so that can be skewed, or Cohen's D, how much power is there. So there's other conventions, right? And I mean, I also think, well, I don't have this dialed into my equation here, but it's also looking at, isn't it, the general composition demographically of the labor market in the geography that you're working in and seeing like how consistent. And to me, there's other pieces
It's
of
that
evidence.
granular. It's
Yeah,
that granular.
it's
Okay.
all
And
yeah,
but not only that, it's per job description within that area,
yeah,
which is
yeah, yeah,
different than other areas of the country for the same
yeah.
job.
Yeah, I know. That's why we sample. I mean, we when I do sample for job analysis or validation, we make sure we hit every geography, right? I mean, it's really important to have that representation. So for me in a practice here, I always advise my clients to do it's a bunch of little things that send a signal that you actually care as an employer, right? It's not just do you have a 4/5 ratio problem. It's all what are all the other things you're doing? And in my experience doing litigation support, there's a lot of opportunity preemptively to say, all right, let's have a third party firm like the one I work for audit what you're doing and come out with some recommendations. And if you comply with those and show that you're, making some changes, you're not going to have to go to court or have a lot of these other things. So there are opportunities for people to get it right once it's been flagged.
I think it's a combination of everything you said. And that's what I've been trying to raise awareness, kind of going in full circle here, is that, there's no one size fits all approach to
No.
HR technology, just like there are no one size fits all approach to anything related to employment, whether it's accommodations, whether it's testing. And in addition to investing in the infrastructure of actually buying these expensive HR tools, which do have a lot of promise to eliminate bias if carefully designed, and properly used. I always make sure to qualify, that in that you have to build that governance structure around that. And what does that mean? That means, working with the vendor to make sure that all the testing is only done on your data, that only people within your organizations that have proper EEO training have access to this, to not inject the bias like we talked about before,
Yeah.
but also doing that pre-deployment testing, doing that yearly bias audit testing as the data changes, as the job requirements change. And we encourage that at the EEOC because that prevents employment discrimination. Doing that at least gives you some certainty that if there are issues, you can change it in advance before discrimination occurs. And that's where we need to get with this. But look, that's a cost. Just like buying this is a cost. But here, it's not like other software where you can just let it go. You're dealing with civil rights, and you have to ensure that it's being used properly, or you're going to be liable for really harming your own workers, which, I believe no employer actually wants to do. So
No.
it's just a lot more to it. And we're also on your point, which I think is really important, is that you're right. We have to deal with, let's say almost every employer in the United States. We also have jurisdiction over state and local and federal government as well, right?
Right.
So we have a very, very big portfolio. And like most government agencies, we have limited resources. So when we get 2 cases of employment discrimination and our investigators show up and one company says, here's what we did, here's what we asked the vendor, here's why we chose this vendor, here's the data set we use, here's the skills we asked to assess for, which is based upon not only the industry standard, but our own business necessity within our organization. Here's the testing we did, and et cetera, everything we've just been talking about, versus another company that we show up and say, I don't know, this vendor promised us diversity, equity, inclusion, and better hiring, and that we could replace our talent acquisition departments by buying this. Who's going to be in a better position, right?
Yeah, exactly. It's bias. I came up with this term bias washing too. Like I audit a lot of websites of I call it now predictive hiring tools, not just assessments, because there's, as you noted earlier, a lot of stuff that's not traditionally seen as an assessment because it's below the surface and sometimes completely unapparent or based on just, NLP, whatever it is. And so, you look at the websites and it's all no bias, no bias, no bias. It's so easy to say that. It's absolutely so easy to say that. And that's why I think one of the cool things that I feel is going to be happening at some point based on commonalities with EU and just common sense in some sense is some kind of auditing of vendors. Probably not locally to the specific use case, but let's look at how you develop this tool. Let's look at, across all your samples, what does it look like? Have you had a board or somebody come in that's diverse and look at the language that you're using? There's the surface level stuff. There's the algorithmic stuff. So do you see that happening here in the U.S. at some point? I know the California law has something about, or it's not a law yet, but there's a couple in California that are working their way, to the Capitol. So what do you think about that?
Look, this goes back to our earlier conversation where you need to follow what other, the federal government here in Washington, D.C., as you know, it takes us a long time to pass the budget to keep, the lights on in these agencies.
Yeah.
So, there is a lot of noise in Capitol Hill now about AI, but a lot of that is around generative AI and copyright issues and privacy issues. Certainly some in employment, but not as aggressive as we're seeing in the States. I think that, you're really going to have to pay attention to what these larger states like California and New York are doing and what, there are the themes that they're picking up on this legislation. Because at some point, as we saw with pay transparency laws within the space, Colorado, then California, then New York, Massachusetts all mandated pay transparency. And at that point, national employers were just saying, you know what, it's going to be too difficult to try to not to slice and dice this between the states. And we're just going to do this across the US. So I think that's where employers need to be looking out for now. And what are those changes? What are those potential requirements? And look, complying with them in advance, creating an advisory board, creating, doing audits, giving consent, whatever it is that these state legislators are pushing for, you can do now. And the more you do now, it's just the more compliance you're going to be with the federal government, which is truly, at the end of the day, going to be everyone's fear just because of the impact we have in a not only a nationwide perspective, but a global perspective.
Definitely. I couldn't agree more. And in my advising, writing, or whatever. It's like it's internal governance. We know what the right things to do are, for goodness sake. So you don't have to have, the government forcing you to do those right things. You can opt to do those right things, and they're not just arbitrary things. They're actually very meaningful things, right? To accomplish the equity we've been talking about.
Right.
Yeah. So let's talk a little bit about uniform guidelines, and let's talk about relevance for, let's say just really black box neural network algorithms. So I've been waiting to use this analogy for a really long time. I hope I can't write it because it's too long, but I hope it makes sense, right? So I'm really into cars. That's my hobby. I'm a huge gearhead. So I have a truck. My truck was built in 1978. So I always think, well, that's when the uniform guidelines were built, when my truck was built. It's a pretty crude machine, right? It's a pretty crude machine. It's very understandable how it works. Well, I got a car business. I upgraded it. I put digital fuel injection on there, right? So I have gauges in there, and all the parameters are monitored. The temperature and pressures and everything, they're monitored by gauges. So it's the same gauge that I have, and it's the same engine that I have, but a carburetor is an analog, metering device. Well, now I've got a computer on there, and I don't know exactly what the hell. Well, I do. It's somewhat transparent. There's maps of different parameters, and you can adjust those. The computer does it automatically. The gauges I'm reading are saying the same stuff, but what's going on behind the scenes to give me those readings is very different, right? If I'm making sense here. So the analogy, which may be a stretch, but I had to talk about my truck because I love it, is that, the uniform guidelines are looking for those signals on the gauges, and the inputs are, the engine is basically the same in terms of a hiring process. But now you've injected a digital thing in the middle, and some of those digital things are not easy to understand what's going on. So how does the uniform guidelines, if I remember it's a lot about construction and validation. I don't know that it gets to the level of what does your algorithm look like, but it does want to know how you built it and what the outputs are. So talk a little bit about the continued relevance of the uniform guidelines to these more sophisticated tools. I think with more simple machine learning stuff, maybe it's pretty apparent, but we get into a territory, especially now with generative AI, where it's supernatural. We don't have any idea what the hell's going on in there. Am I making sense?
Totally making sense, in the sense where also too, where we're constrained here in the executive branch, right? We can't make new laws. We have to just continue enforcing, let's say, older laws to this new technology. But it works in the sense, and we actually put out guidelines on this, and I'll make sure you can link it in the notes to the podcast about how how the Title VII and the disparate impact testing on the 4/5 interacts with this new technology. And look, we are not technologists here. We don't know how to regulate to the technology. We know how to regulate employment decisions. And in a way of simplifying it, we have to just look at the results and look what was put into those inputs. And I don't want to say ignore the middle part of the algorithm, of what the algorithm actually did. But again, it doesn't matter, because it doesn't matter what the human brain did, right? It's just going to be, it's going to matter what the result is. And that's what we keep beating the drum on, is that when you run, you use one of these AI tools to make an assessment for a hiring decision, it's going to be the same, inputs of the applicant pool, the skills you asked that you thought were relevant for the job. And then the output is going to be, well, what was the selection rate of candidates versus the highly selected rated candidates, without knowing what the crazy number algorithm, machine learning, natural language processing, all those AI buzzwords actually did. And we can't have that be a distraction, because if we do, then we're never going to be able to perform these audits. So my plea, and what we've said is that, take what the inputs were, and that's the candidates, the employees, what the metrics were, saying, oh, I need 3 years of this skill, 5 years of this skill. And then, did it have a disparate impact? And if it had a disparate impact, then, okay, can you justify it? And was there at least discriminatory means? So it's going through that same analysis. I don't want to say skipping over the algorithm, but you're going to be liable if what the algorithm did.
Absolutely. Yeah. And that's the take I've had as well. But it's just, as things get so sophisticated, I think people look at 1978, a lot has changed between that now and then. Uh, Let me ask you this. You may or may not know this, but it relates to what we were just talking about. But let's say we're in court, and would it be I'm the let's see, I'm the the plaintiff here, and I'm saying grilling somebody about the stuff they used. Could I say, tell me about the training data that was used to create this AI algorithm? Could you produce where that was from? Like, would the judge throw that out and say, you know what, that's not relevant here because the uniform guidelines don't necessarily talk about that, because that's kind of sometimes the root of the problems with this stuff, right? So is it meaningful in court?
Yeah, I mean, you're going to have to be able to produce that. And I
Okay.
think that
If
gets to an even more difficult issue is who owns the data. And
Yeah,
a lot of these times when you apply for, take an employment AI assessment, you're being rerouted to the vendor's website. The vendor owns the data.
yeah,
But guess what? From the EEOC's perspective, from a, an evidentiary perspective in court, none of that matters.
yeah,
Show us the employer, you are liable. You
yeah.
have
You
the
bought the
data,
gun.
you don't have the data, doesn't
Yep.
matter. You're liable. So when we ask you for it, and there's going to be no defense in saying, well, we don't have it, right?
Yeah,
Let the
yeah,
go get it from the vendor. No,
yeah,
you
yeah,
need to do that. And that's to your point about how do you, the vendors in the space who will rise to the top will be able to answer those. The
yeah,
vendors
yeah,
in the space who will provide that data, who will store that data, just like any other kind of employment record, will be able to meet that challenge sort of in a sense that has been going on for a long time.
yeah. 100%. So let's talk about, we kind of play winding out here. There has been definitely a lot of good stuff coming out of the federal government around, like the No Robot Bosses
Mhm.
Act that's kind of working. So there's a bunch of these things, right? And I guess then you have all these different state laws, even some city laws, right? So do you feel like, and we talked about the uniform guidelines still being the canon, still being very, very important and useful. Do you feel like what's coming is potentially a federal law that knots together all the different things in the, like the No Robot Bosses Act? There's probably, I know there are other things. So there's disparate federal things that are saying a lot of the same stuff and even coloring it in with more information, say on the AI side. Is that going to be all tied up nicely for us in some kind of thing, or is it just, hey, the uniform guidelines are still relevant to all this, we don't need anything new? So what are your thoughts on that?
This is just my personal opinion, of course. Don't bind the EEOC or the federal government. I don't think any of that's going to happen.
Right.
I think it's
Right.
going to be this
Gotcha.
patchwork of state and local laws, still essentially relying on the EEOC in a
Yeah.
way, sort of
Mm-hmm.
to saying like here's the basics. I think
Yeah.
as we've discussed at length, there's going to be add-on requirements, but I don't think you're going to have that consensus from the federal government. I don't know if there's, maybe my prediction is because generative AI, people really understand the issues a lot more with
Yeah.
copywriting, with you know likely the actors and actresses, images and musicians.
Yeah.
Maybe they do something there because it's understandable on the copyright protection,
Yeah.
but I just can't imagine anything just like privacy laws. GDPR in
Yeah.
California has one, and
Yep.
states are just starting to do it themselves. So yeah, I just don't think there's going to be any action universally. But look, you are getting by these bills, you're getting a peek into what potentially powerful
Mm-hmm.
senators or legislators are going to expect from employers using AI. Like you brought up the No Robot Bosses Act. And look, if they're saying they don't want employees being subject to an algorithm for their performance reviews or their management, that's a pretty good sign that of at least what their personal
Yeah.
tastes are. And like, I don't in a way, you should take that as a warning if very powerful senators are saying that this
Yeah.
is what their concerns are. And you can judge your own practices around that.
Yeah, and it just, look, it's like environmental stewardship has been a big one, thank goodness, in the last, probably decade or so. And companies have their own, I mean, they're federal stuff, but companies have done a really good job of having their own internal governance, their own moral compass, if you will, on this stuff. And I think that all the stuff we've talked about today, I just continue to think that companies can be so proactive, excuse me, and so do so many meaningful things under their own power because they know what the issues are, and they have the ability to make their own standards to supplement, that and help make sure they're compliant with the federal, global, planetary, whatever it is stuff. So as we got the last just couple of minutes here, I've started to do this with a lot of my guests. I'd like you to fast forward 10 years to 2034. Well,
Jeez.
describe what you think in your mind the hiring, process looks like, and how are these things governed if in any different way than now,
I think that, I don't think the civil rights laws are going to be amended because they haven't been really in a very
right?
long time. I don't know if there's going to be a new standard relating to employment assessment testing because there hasn't been in a long time.
Right.
What I do think is you're going to see just a general awareness, whether it's through litigation or government enforcement, of actually having cases decided in court, and maybe even the court setting some of the guardrails or parameters of what these laws mean related to AI, which we haven't really seen yet, of course. But I think just more of a general adoption across the board. And at some point, employers have having spending money on that infrastructure to use it properly, because I always say it's no longer a question about are you going to use AI in HR. It's how are you going to use it at this point, for what purpose, and how are you going to comply with current law or any future law. So I think that's where it's all going, and I think at some point there's going to be just a general awareness or understanding of the baseline obligations of what you need to do.
Can you form a vision in your head of what an assessment or a hiring tool is going to look like 10 years from now? Like,
Oh,
there's
geez,
no right
no.
or wrong
I
answer.
can't
No.
even I can't even imagine.
Gotcha.
I couldn't
Yeah.
have created the technology that's out there already, which has
Yeah.
some pretty wild stuff about how to assess employees, the
Yeah.
gamified assessments. So that is way beyond my simple understanding as a labor and employment lawyer.
Gotcha. Well, a lot of the stuff that you deal with is way beyond, my simple understanding too. So thank you so very much. I thank you for being so accessible to people and really getting out there and sharing important messages with people who are practicing, this stuff, building the tools, consuming the tools. We have an obligation to be fair and treat people like we'd want to be treated. I think it all goes back to the golden rule. That's the biggest standard we all have to live by. It's complicated, but that's going to be life here in the age of significant AI, if you ask me. So thanks so much for your time. I know you're busy. Been awesome.
Thank you so much.
Thanks so much for listening to today's episode. I want to encourage all the listeners out there to share this podcast with their friends, families, colleagues. People don't find podcasts just randomly typically. They do so at the recommendations of others that they trust, and, people who've really enjoyed that content and want to share. And I certainly sincerely hope you've enjoyed the content of this episode and the others like it, and encourage you to please share with your friends, family, and coworkers. Let them know about this podcast and what we have to offer. They're going to definitely walk away smarter, sharper, and thinking about some really interesting issues, which is what we all want, right? Thank you very much. Until next time.